Welcome to our first lecture covering ERISA, HIPAA, COBRA, and other benefits-related laws. So let's begin. One of the things that some people are confused about is what must employers provide in the way of benefits? And so let's kind of sort through the required benefits and the optional benefits that employers can provide. So the first are these statutorily required ones. Employers are required to contribute to all employees' Social Security accounts and also to Medicare. This oftentimes appears on employees' withholdings as FICA tax because the employee contributes a portion and the employer contributes a portion of those amounts. And the employer doesn't have an option to opt out. We've talked before about the difference between employees and independent contractors. This is one of the big ones because when a person is an independent contractor, the person who is using that independent contractor services doesn't have to do any withholding for Social Security or Medicare or unemployment insurance or workers' compensation. So you can see that in that case, the employer is actually saving quite a bit of money. The employee, or in that case, the independent contractor, is responsible for making those payments. In the case of the employee, for some of these benefits, the employee has to contribute a portion, but the employer is also contributing a portion. So these are non-optional activities if the person is truly an employee. But there's another category of benefits that are not related or not required for employers to provide. The United States is kind of unusual in the Western world by connecting health insurance to employment. Many countries like England and France and Canada provide for a separate system that isn't related to employment to provide health benefits to citizens. But the way that we have set up our system is that it's mainly employer-based until a person retires. And then that person is typically eligible to participate in Medicare. So the law doesn't, so the kind of the assumption of the law is that most large employers will provide health insurance to most of their full-time employees. That's kind of the working assumption, but it is not a legal requirement for most employers. For very large employers, yes, they are required under the Affordable Care Act, sometimes referred to as Obamacare, to provide health insurance to its employees, or alternatively to pay some monetary penalties if the employer chooses not to do so. But again, that's just really for large employers. And of course, the Affordable Care Act is something that has faced a lot of challenges, probably will face additional challenges, probably will morph over time. So I don't want to focus too much on that particular statute. The interesting thing is in employment law, most of our statutes are pretty lasting. If they're passed, they stick around. There may be some amendments from time to time. But so if the law was passed in 1960 or whatever, it's probably still around, at least in some form. But with the Affordable Care Act, sometimes that, depending upon court decisions and the current popularity of the law, that may affect exactly how that law looks on a particular time. Plus, this is not a healthcare law course. This is a really, really complex subject. You could easily have an entire separate course on how healthcare law works, even healthcare law within the employment context applies. I wouldn't be qualified to teach it, and I'm certainly, even if I were qualified to teach it, I wouldn't be able to talk about it in a brief lecture to really meaningfully cover it. So I'm not going to do anything more than just kind of graze the surface of the Affordable Care Act. But let me just summarize the general rule. Employers are not usually legally required to provide health insurance, pensions, paid sick days, severance pay, or other benefits. If an employer chooses to offer those benefits, the employer has the option to offer ERISA plans, and we'll talk about what that means. Again, there's some exceptions. The Affordable Care Act does require some health insurance for some employers, but again, kind of beyond the scope of our class to do a deep dive into it. You as an employment or labor paralegal would not be enforcing the Affordable Care Act. That would be the ERISA attorneys that would be involved in that level of compliance. Okay, so let's talk about ERISA. So before we go too deep into ERISA, let me just pause and say that most labor and employment attorneys are not ERISA attorneys, and most labor and employment paralegals are not ERISA paralegals. ERISA is a subject that kind of is halfway between tax law and employment law, because ERISA is all about the tax code, and it's all about how this particular part of the tax code relates to employment. So it's kind of a hodgepodge. The area of ERISA law is also interesting just from a cultural standpoint. If you go to major law firms and you look in their tax department, you will find, the income tax department, you will find that it is largely a masculine department. No, I don't mean the paralegals, I mean the attorneys here. It is probably the most male attorney area in a law firm. I don't know why, but it's just true that it is. Then if you look at the labor and employment section, historically that was also a male-dominated area when we were talking about unions. When it was the labor more than the employment side, that was very much on both the employer side and the union side, and very much a male-dominated area. It was rough and tumble a type of practice. But the employment side of things, of course, has hugely grown, while the labor side has significantly shrunk. And so now, and we still call it labor and employment, but now, once upon a time, labor was the big deal and employment was kind of an afterthought. Nowadays, employment law is the big deal and labor law is the afterthought. Well, with that transition, employment law certainly has many male attorneys in the area. I certainly don't want to make it sound like it's all women dominated, but certainly women are very well represented in this particular practice area. And so then the third area to talk about are ERISA attorneys. And ERISA can be housed in a law firm in lots of different places. Sometimes it's its own separate department, just having ERISA responsibilities. Sometimes it is part of the tax department, because even though employee benefits doesn't sound like a tax topic, the tax code is what dictates how the benefits are structured. And so it really is largely a tax practice. So sometimes it's part of the tax department. Sometimes it's part of the labor and employment practice. So it's part of the firm that is supporting employers in complying with labor and employment related laws. Because of course, ERISA is, the first word in it is employee. Sometimes ERISA departments can be in the litigation function, especially if the law firm focuses on ERISA litigation. So there's just lots of different ways of structuring it. I don't think there's one way that's best for all law firms, or universally going to be the best way of doing it. I will tell you that the ERISA department is usually overwhelmingly female attorneys. And so when it's in the tax department, it's kind of weird, because you might have 20 male tax attorneys and 5 female ERISA attorneys. And it's almost that segregated in terms of a department. Yes, if you're an ERISA attorney, you're working with income tax attorneys. And if you're an income tax attorney, you're working with ERISA attorneys. So I don't make it sound like that they're somehow not interacting with each other, but they really are separate specialties. And it would be unusual for a practitioner to really be an expert in both federal income tax and ERISA law. They would know a fair amount about both. Similarly, it would be unusual for an ERISA attorney to be really, really comfortable and fluent with respect to labor and employment law. Similarly, a labor and employment attorney is going to know some things about ERISA, enough to be dangerous perhaps, but not to be an expert. And again, that's where I am. I know more about ERISA than, say, the Affordable Care Act, for sure. But I am by no means an ERISA expert. I would not be qualified for that to be my practice area, for example. So again, it's an interesting, you might even call it an orphan, because it doesn't have kind of the necessarily logical home. If you find this field interesting, it is very possible to practice ERISA law in both a law firm and in a corporation. As of course, you can practice labor and employment law within a corporation. The corporation needs to be rather large to have one attorney who is devoted exclusively to ERISA work. As I think back at JCPenney when I was there, we had 150,000 employees, so there were lots of people in the ERISA plans. And generally, JCPenney had a reputation for having very good benefits. And as I think back, there were typically 3 to 4 attorneys that were exclusively ERISA attorneys, and we did not handle ERISA litigation in-house. Or if we did handle it in-house, it was not by one of the ERISA attorneys. Now, to some extent, having $150,000 isn't really any more work than having 100,000. I'm sorry, having 150,000 employees is not really more work from an ERISA standpoint than having 100,000 employees. And it's probably not that much more work than having 50,000 employees. So you can scale it to somewhat there, since there's economies of scale as you increase the number of employees, because you're not really probably increasing the number of plans significantly. But that gives you an idea that even very large corporations aren't going to need 20 ERISA attorneys or 20 ERISA paralegals. Okay, so that gives you kind of an overview of how these practice areas work together. We're going to be talking in this presentation and subsequent ones about ERISA, giving you kind of an overview of the Employee Retirement Income Security Act, which is what ERISA stands for. We'll talk about requirements of the employer, and especially we'll focus on the requirement that the employer act as a fiduciary. And then we'll discuss pensions, and we'll talk about the various ways that pensions can be structured. In subsequent lectures, we'll talk about HIPAA, which is the Health Insurance Portability and Accounting Act, HIPAA. This impacts hospitals and doctors' offices more than employers, but there are some impacts for employers. Then we will briefly discuss the Affordable Care Act, which is the Patient Protection and Affordable Care Act. Again, this is Obamacare, is another term for this. Again, ERISA's been around forever. HIPAA's been around for a while and is staying around. Exactly what the future for Affordable Care Act is, we'll see in 10 years. My guess is if we have something that's called the Affordable Care Act, it will probably have significant differences. And we may well have a statute that's a completely different name. Then we've had COBRA forever. COBRA is kind of interesting because the name doesn't help you at all. Most of these, the abbreviation doesn't help you. ERISA doesn't tell you what it's about. But once you see what ERISA stands for, you can figure out the topic. Employee Retirement Income Security Act. I mean, you're thinking it has to do with benefits, right? But let's look at COBRA. What does COBRA stand for? Consolidated Omnibus Budget Reconciliation Act. That doesn't sound like it has anything to do with employment law or benefits, right? So the name doesn't help you make sense of it. So it's kind of better to think of this as COBRA. I do want you to know the longer names for ERISA, what it stands for, at least to be able to recognize it in a multiple choice test question. You don't need to know the year that was passed. I think it was 1973, but you're not required to know that. Similarly with HIPAA, I'd like for you to be able to recognize the name when you see it. Don't necessarily have to be able to spit it out yourselves. I don't really care about you knowing this full name. COBRA, I don't expect you to know this full name. It doesn't help you remember it. And I'm going to be honest with you, I don't remember it. I always have to look. I know it has no connection to what the subject is, but a COBRA is a very fine way of thinking about it. That's the way most of us think of it. And then we'll discuss a few other statutes as well. So let's begin. So here we have the Employee Retirement Income Security Act. Again, don't need to know the year. You need to know that it's routinely called ERISA. And please be sure to add this to your Quizlet. So here's our definition. It's a statute that governs benefit plans broadly and not only pensions. It was passed in 1973 to protect employees. And you can see the idea of security here as an important concept. Employers were providing benefits to employees before 1973 pretty routinely, but an employer that was financially struggling or just decided to have a change in approach could snatch those benefits away from employees. And you could imagine how devastating that is for an employee. That may have been the reason the employee chose to continue working at a particular place. And yet now his plans for retirement are gone and there's really no one he can sue about it. Well, ERISA was designed to address that concern. Then we have two categories within ERISA. One category protection are pension plans. So again, be sure to add this to your Quizlet. Pension plans provide retirement income, and we'll talk about two different ways that they are provided. But again, so just be aware that this or a subsequent lecture covers this in more granularity when we're getting near the end of the ERISA section. Then we have welfare plans, and this is a much broader category. Pretty much it covers everything that isn't a pension plan. So it's going to cover healthcare insurance, childcare subsidies, prepaid legal services, various types of insurance products, vacation pay, holiday pay. All of those things are covered under the welfare plans. So if it's not wages and it's not a pension, it's probably a welfare plan. There are a few things that aren't covered at all, those like premium pay or regular pay. Tuition plans are also not covered as a welfare plan benefit. So there are a few things that ERISA just doesn't cover, but not a lot of them. Usually, if you're not talking about wages, and it's something that the employer is not statutorily required to provide, but can provide, very likely the employer does it through either a pension plan or a welfare plan. Okay, so a big deal about ERISA, and I've talked about this before, but you may not remember, is the preemption aspect of it. This is a game changer. This is huge. And this is pretty much the only statute that we really, really have a lot of preemption here. So think about it. You're in Congress back in 1973, and let's say you are a strong advocate for providing employee protections. You feel like the people who voted you into office need greater protection with respect to their employers and the benefit plans that the employers may or may not be providing to their employees. But people across the aisle perhaps are more concerned about limiting the flexibility of corporations. They may say, look, it's great that the employer is providing benefits. If we put too many strings on that, too many limitations on that, maybe employers will just decide not to provide any benefits and the employees will be even worse off than before. So those were kind of the two mentalities. One person, in this case, will say it's you who want to provide more protection to employees, but people on the other side of the aisle are saying, if we require employers to do X, Y, and Z, they'll just opt out entirely. If we make them do all these things for health insurance, they may turn around and say, okay, we're done. We're not even doing health insurance. We don't have to, so we're not gonna. So poor employees, you're stuck. You don't get anything. You used to have something, but because of ERISA requirements, we're going to just say no, thank you very much. So those were kind of the two schools of thought. And of course, naturally, the two groups needed to come together if they were going to pass a law. And so the group that you're in, the people who want there to be additional protections, started talking, saying, listen, yeah, we don't want businesses to opt out of it, but we don't think they will. We think that if we give them tax benefits for providing or continuing these programs, that will be very motivating, number one. And number two, we think that most employers or most employees pay attention to benefits when they make employment decisions. And so employers are going to lose good employees if they don't provide the benefits that their employees expect. So for those two reasons, we think even though this is optional, we're still going to be able to persuade employers to continue to offer these benefits. And so what we want to do is incentivize you, the people on the other side of the aisle, to vote for this statute. And so what the other people said is, well, listen, okay, we might be willing to agree to this statute, but one of our concerns is that, we can control what the federal government does, but we can't control what the 50 different states do. We won't be in those legislatures making those decisions. And so our concern is, yeah, we think people in our home state are going to be reasonable, but what about those crazies in California or New York? They may put all kinds of burdens on employers in this area, and that may disincentivize the employers to provide benefits at all. And that's not what we want to have happen. So what we want is there to be preemption. We don't want California to put more demands upon employers. We want to not just be the floor, like we've seen the federal government be with Title VII and the ADEA and the ADA and the Fair Labor Standards Act. We also want it to be the ceiling, the most that can be required of employers. And again, that is not the same thing as Title VII. So under ERISA, under Title VII, a state like California could provide additional protections like marital status protection or historically, another example would be gender identity. Nowadays that is covered under Title VII, but for 20 years or so, it was considered an additional protection that, say, California or New York or Wisconsin was providing. But ERISA is saying, listen, the federal government is providing the minimum and the maximum for employers that want to participate in these programs. So that's what preemption is about. When we get a little bit farther into this presentation, I'm going to show you the preemption parts of the statute. They're not easy to understand. I'm not going to expect you to unpack them and understand them. I just want you to be exposed to them, I guess you could say. So ERISA preempts state laws even remotely relating to the regulation of benefits plans. We'll be looking at, I think, about 3 cases that talk about this issue of preemption in this section. This applies to not just state laws, but also city laws. For example, let me give you an example. Let's say that a state, I think this is true about Illinois, has a particular scheme for how vacation pay should be paid out in that state when an employee resigns in the middle of a work year but has not taken all of his or her vacation. So imagine we have an employee who's been employed with us sufficiently long that he's eligible for 15 days of vacation that year. He's only taken 4, so he has 11 days remaining. Well, in the state of Illinois had a specific rule about, I can't remember what the rule is, but let's just say, for the sake of argument, that the state of Illinois said, well, the employer is required to pay out those 11 days of vacation pay to the employee when that employee leaves the employment. Let's say that's what the rule was. Well, that may not be the practice of a particular employer, especially a national employer who might be subject to one law in Illinois, another law in California, another law in Kansas, another law in Massachusetts. And so that employer may want to have one rule for all workers, and it may not be consistent with what the Illinois rule is. So that state may say, well, we don't want to follow the Illinois rule. We want to follow our usual rule. So how would that employer handle that situation? Well, the employer would make its vacation pay plan an ERISA plan. And as soon as it becomes an ERISA plan, then the Illinois law is no longer going to apply to payouts under the vacation plan, because again, it's an ERISA plan. Now, if an employer chooses not to make his vacation plan an ERISA plan, and that employer is based in the state of Illinois, naturally the employer is going to have to follow the Illinois statute, because there is no ERISA plan that for which the ERISA statute would preempt any state law. So again, this is an interesting area. So sometimes one of the reasons why businesses want to establish an ERISA plan is to take advantage of those tax benefits, certainly, but also to avoid what they perceive as negative impacts of state law. So ERISA, as you probably have been able to see at this point is a very complex law. I don't pretend to know all the ins and outs of it by any means. It has 4 titles. You know, we talked about the Civil Rights Act of 1964. We had Title VII, so you can see the count. It's even more parts to the law than we see with the 4 titles to ERISA. There are 2 sections of ERISA that I'm going to touch on briefly. The first one is Title I, which is the employee rights provisions. And Title II is the one that establishes the requirements for a retirement plan to receive tax favored or qualified treatment. So again, that's the sweet spot that the employer wants to be in. The employer wants to, or oftentimes uses its benefits plans, be they retirement or otherwise, as vehicles to save some tax dollars. And so you have to cross your T's and dot your I's in keeping with ERISA to make sure that you're eligible to take those benefits. So the first one is about employee rights. That's Title I. The second one is about retirement tax treatment. You do need to know both of these. You go to the next slide. Oops. Here we go. So we have our first case here. Does ERISA preempt the rights of states to require health insurance policies to provide minimum benefits of coverage? Now, I just finished saying that we have complete preemption in this area. What I'm about to say is going to sound like I just undid that, because the answer is no. In this case, ERISA doesn't preempt states in this area. It's going to feel like, well, gosh, there's not so much preemption after all. The 3 cases that I've picked here are probably, maybe they were not strategically the best to pick, because all of them involve kind of exceptions to the ERISA rule. But it's important to remember that these really are exceptions. Here's the ERISA world, and we'll talk about, I think, 3 cases that are exceptions. But the general rule isn't one of these asterisks. It's all the space between the asterisks. So don't let the fact that I'm talking about exceptions throw you here. These are not the main category here. Okay, so the state of Massachusetts enacted a statute requiring that certain minimum mental health care benefits be provided to state citizens who are insured under a general health insurance policy. So MetLife, of course, is a major insurer. It contended that ERISA preempted this legislation. So its position, MetLife's position was, we don't have to comply with this Massachusetts state law if we're administering an ERISA plan, because ERISA has preemption of state law. And of course, the state of Massachusetts says, no, you need to comply with our state law because this is an insurance law. And insurance laws, which we'll see in a few minutes, continue to be in effect. Well, the court agreed with the state of Massachusetts. The court concluded that mandated benefits laws, such as this one, were not preempted by ERISA because the Massachusetts statute is a law which regulates insurance. So the key word here is insurance, and that is an exception to the preemption. Now, you don't need to know the name of this holding or its case, or no, you don't need to know this holding or its case, I'm sorry. But let me just take a pause here and show you the OIA for this particular. Okay, so here we have it. This is the OIA website. This is such a neat website. If you haven't just played around with this, I highly encourage you to do so. You just type in oyez.org. OIA is what the bailiff of the Supreme Court says before the beginning of the case. If you speak French, you know that this basically means hear this. All you people hear this. So it's kind of like hear ye, hear ye. We sometimes imagine bailiffs saying this is the French version of that. And of course, our court system comes from England. And of course, in 1066, William the Conqueror invaded England. And of course, he was a Norman, so he spoke Norman French. And so the language of the courts for hundreds of years was Norman French. And as a result, we do have a fair number of French terms in our vocabulary, legal vocabulary. And this is just one example of that. Anyway, so this is the website. It's just about the U.S. Supreme Court. It has so many cool resources. You can see in this case, actually not this one, But you can see here, you can listen to the oral argument. You can also see the syllabus, which is just a fancy word for the summary of the case. And you can also view the printed case in this situation. And you can see how the various justices voted. In this case, it was a unanimous decision, which of course meant it was, I guess it was 8-0, because Justice Powell did not participate in the deliberation of that case at that time. Let's go to our next one, and that's going to be Rush Prudential. So in this case, is an HMO, which of course stands for a health maintenance organization, an insurer for the purposes of the insurance savings clause of ERISA preemption. So again, we have this insurance saving clause. So the general rule is that ERISA preempts state laws unless it has to do with insurance. And so the issue is a rule about in this case, an Illinois statute about HMOs. Is that an insurance regulation, or is that the type of regulation that ERISA would preempt? And in this case, again, they found, or the U.S. Supreme Court found no preemption that the Illinois statute can stand, because it has to do with health maintenance organizations. And in this case, this HMO denied the patient's request for surgery on the ground that it was not medically necessary. And I guess Moran is a woman, so she makes a written demand for an independent review. The HMO refuses her demand. She sues. It goes up to the U.S. Supreme Court, and the Supreme Court held that prior to ERISA's passage, so before 1973, Congress demonstrated an awareness of HMOs as risk-bearing organizations subject to state insurance regulation. Now, this is a product kind of like an insurance company, in other words. And so the court held that ERISA does not preempt the Illinois state law. Now, I've included here a link to the OIA for this particular case. Let me just go to that and show that to you. Here we go. Click on that in just a second. So again, here we have the name of the case. And again, you would just type it up here in the search engine when you go to oia.org. And you can see most of the cases that you find on OIA are going to have this lovely fact summary. It's going to show you the question that's presented, and it's going to give you just a paragraph or two explanation. It shows you the vote. This is a 5-4 split. But a neat thing, we didn't see this on the first one, the Metropolitan case, but we do see it here with the Rush Prudential, is the opinion announcement. Now you can listen to all the oral argument, you can still read the syllabus, the summary, and actually read the case. But this is so neat, and I just love this. I'm not going to play it here, but it's, in this case, a 3-minute summary of the decision of the court. And again, you will actually hear Justice Souter's voice, and this is the literal words that Justice Souter is speaking as he goes through this. So this is just a lovely, lovely summary. I highly recommend you to listen to these. This makes the case much easier to understand. I'm going to actually go over some of the preemption law now that we've looked at Metropolitan and Rush Prudential briefly. So here is the first section that we're looking at. And this is the first preemption. Then we have here the exception. Well, this may be another part of the preemption. Let's see here. Now here is the insurance exception to the preemption. Again, I'm not going to spend a lot of time. I'm just showing you kind of how we unpack the various components to this. So this gives us an exception when it has to do with any law which regulates insurance. There is no preemption in that case. And then we have our last one, which is another preemption section here. Subject to paragraph 2 and except as provided in subsection B. And paragraph 2 would be right here. And subsection B is all of that. So we're a little too far. Subsection B is this. Subject to paragraph 2 and except as provided in subsection B, this part shall not be construed to supersede any provision of state law which establishes, implements, or continues in effect any standard or requirement solely relating to health insurance. Oh, yeah, this is another part of the insurance exception. And then here they have nothing in this part shall be construed to affect or modify the provisions of section 1144 of this title with respect to group health plans. So again, it has this one little carve out for insurance law with respect to the preemption requirements. Now, the two examples that I provided have showed where where the court has said preemption doesn't apply in these two situations. Just always keep in mind that these are narrow exceptions. In the vast majority of state situations, the court is going to not allow state law to apply when we have an ERISA plan in effect. Okay, let's look at our third case. Can states prohibit HMOs from limiting their provider networks as an exemption from preemption of ERISA? And again, they say no preemption. And again, in this state, Kentucky, depending upon your experience with HMOs, in some states, and before 1994, I guess this is more generally not permitted, but HMOs were like, any other business. They kind of got to pick who they did business with. So let's say I were a doctor and I wanted to sign up with Bob's HMO. And I met all the requirements. Bob's HMO required, a certain amount of staff, a certain, financial situation or whatever the requirements are. And I could say, I meet this requirement, I meet this requirement, I meet this requirement. I met all of Bob's HMO's requirements. Well, Bob could still say, we're not that impressed by your office. I mean, you meet everything, but we just don't want to do business with you. And in most states, the HMO has the right to make that decision. But Kentucky said, no, we want all HMOs to be required to contract with any doctor or hospital that is willing to meet its requirements. So the HMO has to have these defined requirements and then accept all takers. And so in that situation, at least in Kentucky, I, the doctor, could force the HMO to enter into a contract with me. Now, the issue, of course, was that lawful, or is that state statute, that Kentucky statute, which limits the flexibility of HMOs about who they contract with, was that beyond the scope of, the ERISA preemption? And the court said, no, there is no ERISA preemption. This falls into that insurance category, and so therefore this Kentucky law is A-OK. The court held individual states can regulate HMOs. It upheld the Kentucky law that required insurers to reimburse services of any healthcare provider who is willing and able to meet established criteria. Again, you don't need to know this holding or this case. Let me just show you for a second the Kentucky decision here on OYA. And again, here is the report. You can see it's 5 minutes long. Again, here we're going to hear Antonin Scalia. He's someone he's passed away now, you may not have heard his voice before. And so it's kind of interesting to hear people under those circumstances. You'll see a lovely little summary of the facts. You'll see the question presented, a very brief conclusion. And if you want to do it, again, you can see it's a unanimous decision. And if you want to do a deeper dive and actually read the case, then that's available here as well. You aren't expected to do these things, although I do think listening to the opinion announcement is a really interesting and helpful tool. You don't have to if you don't want to. And again, this is not something you need to know the holding of. You do need to know that the preemption is broad and that the insurance is an exception. But other than that, I don't expect you to get into the weeds on these cases. Okay. So we've covered an introduction to ERISA. Let's go on and talk about employer requirements. So again, we're going to be talking first about Title I, and this requires that employers advise employees regarding the benefits that the employer is offering. We're going to see that this is a document called a summary plan description. Then, of course, the employer has to deliver those benefits. I mean, that seems pretty reasonable. And if the employer decides not to deliver a particular benefit to a particular employee, then the plan that the employer is using has to provide for some kind of appeal process. Also, the employer is required to manage the assets of that plan in a responsible way as a fiduciary. And there can't be any retaliation against the beneficiaries who exercise their rights under the plans. So what is a summary plan description? These are usually called SPDs, and despite their name, they aren't short. I mean, there is a longer document out there, so I guess in some sense they're shorter than the longer document, but they are not by any means short. So I'll show you an example of an SPD in just a second. That's usually what they're called. This has to be provided to the employee within 90 days of when the employee becomes eligible for benefits. They are designed to be written at the level of just an ordinary person reading a document. You're usually shooting probably for 9th grade, maybe even a little bit lower reading level. And you want to strip away the legalese. There'll be some sections that are more legalish than others. But for the most part, especially the non-legal notice section, you want it to be very, very approachable. It does need to be comprehensive despite the use of the word summary. And of course, it needs to be accurate. The employee needs to be able to have the information that he or she needs so that he or she knows what he or she is entitled to and how he or she can access those rights. Specifically, the SPD needs to identify who the plan administrator is, what are the conditions for eligibility, what the benefits are that are being offered, how does an employee file a claim for benefits, and appeal a denial of benefits. Those are some categories. So I pulled up one SPD just to give you a sense as to what they are. Right here we have Walmart's. And it's very common, some employers will have several separate SPDs. This one is just one really big SPD. There's advantages and disadvantages to both. An advantage to having one is that it's kind of one-stop shopping. You just have to send one out. A disadvantage is that it can be overwhelming. As you can see here, this one is the size of a telephone book. It's 300 pages long. Another problem can be that probably many employees won't be eligible for all of these benefits. And so you've given information to employees, and then the employee may assume, oh, I see here I have truck driver long-term disability, even though I don't drive a truck. Well, you can see how that could be very confusing for employees. So you're killing more trees than maybe you have to because you're giving all of the plans to each one of the workers. So there's kind of some trade-offs there, but again, in this particular case, Walmart decided to have the one book. And you'll see here it's designed to be quite approachable. Welcome to your 2018 Associate Benefits book. This is where you'll find the summary plan descriptions for the Associates Health and Welfare Plan, aka the plan, and the Walmart 401k plan. It's a great resource to help you understand your benefits. So take a bit of time and get to know them. Again, you can see it's very intended to be very approachable. lots of information, so easy to find. And it tells you kind of where to find various information. If you're concerned about eligibility, you can look here. Oh, here, I'm interested in tobacco rates. What do I have to pay if I'm a tobacco user? You could receive lower tobacco-free rates for medical and prescription drug coverage, optional associate life insurance, optional dependent care life insurance for a spouse, and critical illness insurance if you and or covered spouse and partner do not use tobacco and are considered to be tobacco-free, and blah, 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 blah. And again, here they define what tobacco-free means. Obviously, it's a very thick book, but you can see the tone of the book. It's designed, even though it's a lot of stuff, and even though there are very few employees who actually read it, it's designed to be written at a level that an average person can read and understand. That's important because if it's written at too high a level with a lot of legalese, and then you start denying claims, that employee is going to have a legal basis for saying your summary plan description didn't provide me with the information I needed. And then you might be in a situation where you can't deny claims you otherwise would like to. So it is important for the employer to make sure you're really writing it in the plain English format. This would be a very common task for a paralegal to be involved with. Writing this, rewriting it, tweaking it, getting it down to a level that is understandable to the average non-legal professional. Let's see here. Let me just do a couple more slides. So as we've already said, ERISA doesn't require that employers establish benefit plans, but it does require that if an employer is going to have a plan that he wants to designate as an ERISA plan, that the employer meets certain requirements. If the employer does set it up as an ERISA plan, then an employee who doesn't get to access those benefits can sue over it. I mean, think about it. When you're an employee or when you're an applicant, say, the benefits that the company is offering you may be a really important reason why you went to work there. And so if they can tell you, oh, we're going to give you all these great benefits, so you go to work for them, and then you discover it's all a farce, that's pretty bad, right? I mean, because really your benefits are the equivalent of your wages, because, if you didn't get the benefits, you'd have to be buying this stuff out in the open market. It costs money, benefits do. And so it makes sense that employees can sue their employer or the ERISA plan, not directly their employer, but can sue their ERISA plan when the ERISA plan denies them the benefits that they feel they are entitled to. Now, it's not super easy to sue the ERISA plan because, again, the ERISA plan it's almost like it's a judge in a way, because it's going to be deciding, it's going to look at all of the evidence, all of the facts, your medical diagnosis, what the doctors say, what the odds of this treatment actually being effective, how expensive the treatment is, and it's going to reach a decision. And just like in most courts, the Court of Appeals, the next level above, isn't going to second guess the trial court. It's going to be what's called an abuse of discretion standard. It's going to assume, well, probably the plan administrator got it right. Probably the plan administrator used an appropriate balancing situation. Only when the plan administrator was really kind of out on a limb, not doing what was reasonable, what the standard is in these types of situations, is a court going to say, yeah, I think you, the employee, was incorrectly denied this benefit. If an administrator does deny a claim, it's going to have to base its denial on those plan documents. It's going to have to explain why it made the denial based upon those plan documents. And it has to use the information that has been provided. It can't just say, well, we just never like to approve this. It has to show why, in its opinion, this wasn't medically necessary, for example. An employer that decides to deny a claim is going to have to show that the claim itself was unreasonable. And if it denies the appeal, that its appeals procedures were reasonable under the circumstances. Employers can't charge employees fees for filing claims or filing appeals. Generally speaking, the ERISA plan has to issue a decision within 90 days of when a request for benefits or a claim has been filed. But in many cases, it needs to be much sooner. So for example, there's an urgent situation. We need to know whether we can get the surgery or not. Those types of situations where time is of the essence, the insurance or the plan administrator needs to decide within 72 hours. An employee can't just jump the gun and say, well, the employer isn't granting me what I want, I'm just going to go ahead and sue. There is the responsibility of the employer to exhaust its administrative remedies before it goes ahead with its lawsuit. And the way that the employee can do that is by using that process that's described in the summary plan description. So if you can't forego that, it's kind of like the need that you have to file with the EEOC when you have a charge of discrimination. You have to dot the I and cross the T before you can go forward. So the plan administrator is the fiduciary. So what is a fiduciary? Well, a fiduciary, again, this is a good term to add to your Quizlet. A fiduciary is someone who has discretionary authority over the investment or management of plan assets on behalf of others. So the fiduciary isn't acting on his or her own benefit, but on the benefit of all the people who are participating in the plan. So what's the standard? The fiduciary must exercise a prudence, a reasonable person. Again, this is a term we've seen again and again in the law. You've probably heard it in every class you've taken, or if not, most of the classes you've taken. And it's the same standard we hear. How would a reasonable person conduct the various investing and diversification of the financial portfolio? It wouldn't make sense, for example, for a fiduciary to put all of its assets into a dicey stock. Maybe it's going to pay off big time. Maybe the stock will go belly up. That's not a good investment. Maybe you put a little bit of money in a dicey stock, but you're going to have that diversified portfolio, some risky, some safe, that combination. Their fiduciary duties of the plan administrator would include managing assets solely for the benefit of the beneficiaries. So the company isn't benefiting from the assets of the ERISA plan. It's the beneficiaries, and it has to be done prudently. It's not a matter of just, well, I intended to help the beneficiaries. Well, that's not good enough. Were you doing sensible things? You need to diversify plan assets if this is a pension plan that you're managing. You need to monitor progress. If it looks like that particular stock is not going to be a good investment, you need to move that money to somewhere else. And you need to make sure that the investments you're making don't pose a conflict of interest. You need to provide accurate information so that the employees have a basis for knowing, is this a good place for me to put my money or not? Should I be investing this 401k or not? You have to reveal that information to the employees. So here are some trademarks of what a fiduciary needs to be. He needs to be loyal, or she needs to be loyal to the person who is trusting them. The fiduciary's behavior or conduct needs to be for the exclusive benefit of helping that beneficiary. He needs or she needs to act prudently, wisely, according to kind of the received ideas about how people in this role ought to act. There needs to be asset diversification. And of course, the fiduciary needs to comply with the SPDs. And make sure that he or she is doing what the plan requires. We will look at LaRue when we have our next lecture. I'm going to go ahead and end it here. If you have any questions, of course, please pop into my office hours. I will be delighted to discuss them in more detail. I thank you so much for your attention, and I hope that you have a wonderful day. Take care.